Good afternoon, everybody. Happy Saturday. Welcome to Eating the Elephant here on Facebook Live, where we talk about Hurricane Michael recovery tips and insurance information. And yes, we are way outside our normal time block. Realizing that tomorrow is Super Bowl Sunday and everybody's either going to be watching the game or watching the commercials, I suspect the last thing everybody's going to have on their mind is dealing with their insurance claim and wanting to watch an insurance nerd like me babble on camera. So I figured I would catch up with a few things since we had to miss last week when I was in Gainesville. And there are a few things that are, I think, timely and topical, and I'll try to get through them quickly, and we'll make this a short episode tonight. But I got some information from somebody this week about assignment of benefits, and apparently there were some postings on Facebook about how to get out of an assignment of benefits contract. I haven't been able to find the post, and it was not even attributed to a particular person. So I did the information that I got. There was some that was wrong, some that was incomplete, but since I can't find the original post, I'm not sure what might have been there. So I wanted to kind of clear a few things up for people so you didn't get into a bad situation and sign an assignment of benefits or AOB thinking that it would be something that was easy to get out of. There are some insurance companies that have tried to insert language into their policies that restrict the ability of contractors to have assignment of benefits. Ark Royal is one, Security First is one. They have inserted language requiring that all named insureds, including the mortgage company, sign off in order for an assignment of benefits, post-loss assignment of benefits, to be valid. And that means the husband and wife or joint owners of a home, if they're not husband and wife, and any lender would also have to sign off. We don't think we've heard of any lenders that are willing to sign off on an AOB because they certainly understand the problems that an AOB can bring about. But what we wanted you to understand is that this is untested, and if you rely on this, you're doing so at your own peril. The 4th District Court of Appeals and the 5th District Court of Appeals have come in on opposite sides of whether this language is valid or not, and whether insurance companies can restrict assignment of benefits language this way. And frankly, what's going to happen now is that it's all going to go to the Florida Supreme Court. The Supreme Court has agreed to take up the issue because of the conflicting decisions so far, and I think that's the proper thing to do. My guess is sort of reading the tea leaves. I think the Supreme Court will probably punt on this and kick it back to the legislature. Whether they find this assignment language or these restrictions on assignment valid or not is still up in the air, but I suspect that they will. We'll just have to see, but what I wanted to make it clear to everybody is that this is untested. It is not finalized in the courts, and it is not something that you can rely on necessarily to get out of an AOB. In our office, we have seen only 2 cases where where a contractor has let a client out of an AOB assignment. And one was due to shame and one was due to duress. In one case, the client's parents owned a law firm, or the father owned a law firm, and he wrote a letter explaining that the kids were under duress. Somebody approached them 3 or 4 days after the storm. They had no roof, like a lot of folks have found themselves in. And so they were able, frankly, to get free legal work. I don't know how much that would cost if you went out and hired an attorney to get you out of an AOB, but I suspect the AOB, if it costs $2,500 to get out of it, would be less than the legal fees. And I don't know that for sure, so I'll leave that for the attorneys out there to decide and to post upon if they like. The other thing that we did was we found shame also worked in one case, where when we saw some abusive behavior from someone that used an assignment of benefits against a client, we put their name out there on Facebook, we argued it, and basically embarrassed them into walking away from that assignment of benefits. So there are some things that work, but don't ever sign an assignment of benefits contract under the assumption that you can get at it later. It's a valid contract that is tended to hold up, and I think if you talk to any lawyer, they'll say, you signed a contract just like any other, like a lease agreement or a purchase agreement, and it's probably going to be held valid by the courts. So are there limited times when things like this have happened and assignment of benefits has been tossed? Sure, but it's the exception and not the rule, and I don't want you to rely on it. as one further illustration of why assignment of benefits is a bad idea, I've got the story from someone this week when I was traveling about the roofer with no ladder. This was, I believe, after Hurricane Michael, not after Hurricane Michael, after Hurricane Irma, as I recall, not after our storm. There was a roofer that was going around, well, roofer in quotes, running around getting contracts signed, promising delivery, promising work, and with a typical $2,500 penalty for someone getting out of an assignment of benefits. My understanding is he had 53 contracts signed, and the guy didn't even own a ladder. He had no intention whatsoever of signing on and actually putting any of these roofs on. He was able to convince a court that he had good intentions of doing this, and what he was going to do was go out and he was going to hire other people to do that. There was no evidence he'd ever done it, and if you think about this, let's say it's a $2,500 penalty to get out of the AOB. Well, if you sign up 53 people and you don't have to do any work and you make over $100,000, is that seedy? Is it unethical? Sure, but it's also very lucrative. So that's one of the reasons that assignment of benefits can become a problem. Probably some of those people were able to get out of that assignment of benefits obligation, but even so, the headache, the hassle, and the time delay in putting on your roof just seems so unnecessary. So while there are people out there in the public and on Facebook touting the idea that assignment of benefits can be a benefit to the homeowner, and or especially I'm hearing now more often that a limited assignment of benefits, if you limit it just to mitigation or just to roofing or just to a particular part of your job, while that can be something that people find acceptable, I have to tell you it's something I still advise against. I would encourage you, however, as much as I advise against assignment of benefits in all its forms, I think you should get other opinions. You should do your own homework, do your own research. You should look up articles on the internet where possible, and you should get in contact with people that think differently than I do and see what they have to say and see if they can defend their position. My position is that an assignment of benefits contract benefits only one person, and that is the contractor that is requiring that you sign it. So I'm going to leave that now, and I am going to say we talked in a previous episode about premium increases and people getting concerned about increases in premium due to Hurricane Michael. I said that wasn't going to happen. Premium increases are going to be very modest, I think, at best, and some people, because they have new roofs, will see their premiums go down. We have gotten a notification from the National Flood Insurance Program, however, that effective April 1st, flood insurance premiums will rise an average of 7%, 7.3% actually in the state of Florida, and that will vary widely by location and by zone. So everybody be aware of that. That was in the works long before Hurricane Michael hit, and that is a national issue. It is not restricted to Florida, and it is something the federal government was working on long before this storm hit. The data that went into that decision was well before Michael hit, so I don't think it has any relation. So I don't want you to get confused and see an increase in your flood premium and think suddenly that the sky is going to fall and everybody's premiums are going to rise. It's not going to happen. A reminder too, that if you have damage to your home, it is very likely that you cannot be canceled by your insurance company unless you don't pay your premium. And I wanted to stress that fact because a lot of us have our insurance escrowed through our mortgage company, and mortgage companies with a great deal of frequency actually forget to pay premiums on time. We see this probably 2 or 3 dozen times a year in our agency, and in normal times insurance companies understand this problem and they are willing to go back even after the date sometimes of renewal and reinstate the policy back to the original date that it was supposed to renew if the fault was the lenders. It just makes more sense that way. Now, we are not in normal times. We are in extraordinary times here. And it's certainly possible that insurance companies would be less cooperative and they would use a non-payment issue like that as an opportunity to get off of a policy if they wanted to do that and not be faced with the restrictions that have been imposed by emergency orders. But we did post the emergency order, a copy of it in some of the hurricane forums and certainly on our Facebook page. And if you're curious as to the actual language or the actual restrictions, you can read it there. It's only a single page from the Department of Financial Services. One other thing that's come up, and I'm going to leave you with this today, there's been a lot of talk on the hurricane forums on Facebook about open and closed claims. There was some data put out by the Department of Financial Services, or it may have been the Office of Insurance Regulation. They're pretty close to one another. Talking about the number of claims that had been closed, and I believe the number was 65 or 70%. It was something like 2/3 of the claims from Hurricane Michael are showing as closed. I want to explain to everybody that that's data that's collected by a governmental body, but for you and me, that data is completely useless and certainly not indicative of what's going on here in Bay County and surrounding areas. Just because your claim is closed, that's an administrative matter. It doesn't mean your claim is finished. It doesn't mean your insurance company is trying to stop any further payment. The reopening of a claim is as simple as the click of a mouse. It is very, very easy. And what I want to get across to everyone is that no matter what your insurance company says, and no matter what the file says, your insurance company closes your claim for good when you say. You can reopen, you can reapproach. There's lots of ways you can get back to your insurance company. And just because it shows closed, I'll give you a little inside baseball, a little bit behind the curtain. An awful lot of insurance companies use what they call independent adjusters, which are not employed. There's third-party contractors that come in after a hurricane because so many people are needed so quickly. An independent contractor is paid when the claim closes. So when they go out and they do a scope, they walk around your house, they come back and they do the Xactimate estimate that we've all gotten familiar with. They send that in, and then they immediately get it closed. And that way, that lets them get paid by the insurance company for their work. Everyone knows that claim is going to be reopened. Again, it's an administrative matter. And what that does is it sort of seals the claim with regard to the independent adjuster so they can get paid according to whatever that claim settlement was right then. Then it's reopened and then we all pay what we know is going to be probably at least twice whatever that initial scope is. So don't get concerned if you see a closed claim. The only time you should be concerned is if you get an actual claim check that says full and final payment or something very much like that. Even if the claim settlement, the stub on the check says something like that, it is not going to be something that is full and final payment from a legal sense unless those words are printed actually on the check itself. So don't get too concerned about closed claims. They're closed when you say they're closed. I'm going to leave it at that. I hope everybody has a good weekend. I hope everybody enjoys the Super Bowl tomorrow. And I would like to give a shout out to Alan and Ray Cotton, who are just opening Beefs at the Beach. And I will tell you, that's going to be a great place to watch the Super Bowl. I'm sure it's going to be the first time they're open to the public in their new location, in their new restaurant. And I hope you'll go take a look and go see them. Good luck to you, whoever you're rooting for, especially those of you that are more concerned about rooting for the commercials and getting into a food coma. Thanks very much. We'll see you next Wednesday.